It was the biggest, most divisive trial of 2024. Karen Reed accused of murdering her boyfriend, Boston police officer John O'Keefe. Prosecutors say she ran him over in a jealous, alcohol-fueled rage and charged her with murder. But the defense painted a different picture, a police cover-up spearheaded by the lead investigator, Trooper Michael Proctor, who they say framed Karen Reed for murder. The case divided the community and created a very intense situation at the courthouse. Karen Reed supporters dressed in pink, while those who supported the police wore blue. The same divide apparently existed in the jury room as the case ended with a deadlocked jury in the 3-count indictment. But afterwards, the defense says 5 jurors came forward to say they actually unanimously agreed Karen Reed was not guilty on counts 1 and 3. But the judge denied the defense request to bring the jurors back to court to find out if they actually reached verdicts on those 2 counts. And now the Massachusetts Supreme Court will make a decision. Meanwhile, both sides are getting ready for the 2025 retrial, and we're back in court today. And we have all the latest, plus analysis from our trial insiders. I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. All sides, all parties, everyone associated with the Karen Reed case agree that the death of John O'Keefe was absolutely tragic. That has made this case so different than many that we cover here on Court TV. Many times there's an attack of the victim. It's the victim's fault. The victim did this, the victim. None of that in this case. And that has to be clear, whether you are on the side and the folks supporting Karen Reed or Karen Reed and her team. They all agree. No one is attacking John O'Keefe. There's just a sharp divide about what happened here and who was responsible. And that brings us to Karen Reed. And the question is she a victim of a cover-up, or is she a villain? Someone who struck and killed John O'Keefe and has not acknowledged what she did, and now is pointing the finger at completely innocent parties. It's one or the other. There's really no in-between for all of this, because she either did it or she didn't do it. If she didn't do it, she's a victim. If she did do it, at this point, she's a bit of a villain, right? Either she's been accused of this horrific crime, something that is likely bankrupting her, completely destroying her life, or she ended a life and is destroying the lives of all the people that were connected to John O'Keefe that night. It's one or the other. And that's what made this case and this trial so divisive. So as we move forward, we have a brand new prosecutor in the case who will be leading it. Hank Brennan will be taking over for Adam Lowley. We all experienced that first trial. It was long. I think the next one will probably be a little bit shorter, just as a result of a new prosecutor sort of trimming the case down a little bit. But it's a brand new approach. It's going to be different. It's going to be way different. As a matter of fact, this new prosecutor is trying to track down some new evidence in the case, believe it or not. New evidence. This prosecutor is trying to uncover. So what is the new evidence? What is it related to? Well, everyone was in court today, so I want you to take a listen to the prosecutor here, talking about some phone records he wants. Phone records of Karen Reed's father. Take a listen.
Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Ms. Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. It will be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e., Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone.
So they're going after Karen Reed's father's phone because of these calls that are made. Let's go back to the original trial, right? Brian Tully, Lieutenant Brian Tully on the stand talking about all of the calls that Karen Reed is making that night into the early morning hours. Let's take a listen.
You've had occasion to review information related to the defendant's phone?
Yes.
Now, you mentioned that about 4:45 in the morning she made phone calls trying to ascertain, or allegedly trying to ascertain the whereabouts of Mr. O'Keefe, is that correct?
Yes.
Prior to those 4:45 a.m. phone calls, were there other phone calls that the defendant placed?
Yes.
And to whom did she place those calls and about what time?
Starting at 12:33 a.m. to 6:03 a.m., there were 53 phone calls from Ms. Reed to a phone number associated with John O'Keefe.
And in addition to those phone calls to Mr. O'Keefe's phone, what, if any, other calls did the defendant make prior to those 4:45 a.m. calls?
There were phone calls to her family members, to Jennifer McCabe, Kerry Roberts, the Cameranos.
Now, the phone calls to family members of her own, the defendant's family members, those were specifically to her mother and her father, is that correct?
Yes.
And did those phone calls precede the phone calls to either Ms. McCabe or Ms. Roberts or anybody else earlier that morning?
On the call detail records, they don't appear, but I know the phone dump has other information.
Okay, so they have Karen Reed's records. So it's all about Karen Reed calling her parents. And you heard what the prosecutor said. He said, well, the inference is that she did something terrible, so she's calling her parents 1:30 in the morning. So they want the parents' phone records for 30 days beforehand to show that, hey, she never calls them at 1:30 in the morning ever. Right now, the state says the interest in William Reed's Verizon phone records stem from this interview he did earlier this year with Boston 25 News. Take a listen.
During your first discussions with Karen, did she believe she may have hit John?
No. No. She felt she struck something. She said, Dad, I think I struck something. I said, what do you mean? Right? This was in the hospital. Right? He says, I remember, all right, backing up and hitting something.
Okay, so that's where the prosecution is going, that she's admitting that she struck something when she's going back. Take a listen now to Elizabeth Little, one of Karen Reed's attorneys, responding to this request for Karen Reed's parents' phone records, all relative to this alleged statement and what it means.
The Commonwealth, in its affidavit, set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, I believe I hit something, was the Chevy Traverse, which the court knows. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17.
Okay, so there's two things here really going on that I want to get to the bottom of. One is going after these phone records. If they have Karen Reed's phone records, what do you need the father's phone records for? And why don't you just call him to the stand and ask him what she said, right? Because that's what you're getting to the bottom of. Was there a phone call? Was there not a phone call? When was the phone call? You've got her records. I'm trying to understand that. And then the other part is, what did she actually say to her father? And does it help her or hurt her? Will it help the jury figure out the truth? Joining me tonight, Karen Reed supporter, creator of Justice for Officer John O'Keefe and Karen Reed Facebook page, Nick Rocco. Also joining us, criminal defense attorney Joseph Krowski Jr., and finally the YouTuber behind Yellow Cottage Tales, Kevin Lenahan. Great to see everyone. I'm going to start with the guy down here, Joseph Krowski, because I'm going to get to the legal part of this. Joseph, if they have Karen's phone records, why do they need dad and mom's phone records? Is this going above and beyond? Is there something else really at play here?
No, and I'm glad you're having me back. I wish you had one of your body language readers watching today to watch Karen, including the part where she lashed out at reporters afterwards. This was a terrible day for Karen Reed. So they have Karen Reed's phone, but if you listen to the hearing, because she's a defendant, they sent that phone through a taint protocol, a taint procedure, to make sure that there was no contacts and communications between Karen and any of her attorneys. So her phone information might not be complete. Second of all, the Commonwealth is not required to rely on her phone. If William Reed takes the stand and they present him with her records, he could simply disavow and say, those aren't my records. I didn't make that call. What we do know from the records is Karen Reed, at 1:19 a.m. that night, called her mother's phone, which is a really unusual thing to do for a 40-something-year-old woman, unless something triggered that call. There were two other calls at 4 o'clock in the morning.
But let me ask you. We know that. Why do you need the father's phone for that? Like they have Karen Reed's phone records.
Because that's, first of all, one, it's the best way to authenticate the records. When you have the good faith basis that a call was made, of course, you're then going to go to the witness's phone records, get his records with the correct subscriber information and everything to authenticate them. But let me make the biggest point of all of that. William Reed, like his daughter, is not afraid of the cameras and making speeches. There's a call between William Reed and his daughter at 6:32 in the morning where she supposedly says, Dad, I hit something. What Hank Brennan did was brilliant. If you line up the time of that call, that's right after she finds out that John O'Keefe, well, she probably knew it, but that's right after everyone else finds out John O'Keefe is dying on the front yard at 34 Fairview. Do you really think the topic of conversation is, Dad, John's dying? By the way, I think I hit his Traverse a couple of hours ago and maybe cracked the tail light. Do you have a good auto body repair guy? It's absurd. The reasonable inference is she called him at 1 o'clock in the morning because she knew she hit John. They have a conversation at 6 in the morning. The father wants clarification, and that's why she says, I think I hit something, and the something is John O'Keefe. If we're going to be intellectually honest, it's the only thing that makes sense. One final point. You said neither side has been attacking John O'Keefe. Well, I will say maybe not John O'Keefe, but they've certainly been attacking John O'Keefe's mother, while Karen Reed sits idly by. Well, she finally got a little taste of her own medicine today. She was on her heels.
Nick Rocco, what's the story from your perspective behind these phone calls to mom and dad by Karen Reed?
So she never called her father at 1:30 in the morning. The first phone call to her father was at 6:32 in the morning. And she did not tell her father on the phone call that is when she potentially hit something and backed into something. She told Bill Reed that in the hospital. he specifically said that actually in his interview, that when he was in the hospital, that's when Karen said that. So that initial phone call at 6:32 to her father most likely was to let him know what was going on outside. Now, as far as the 1:14, 1:30 call to her mother early in the morning, I mean, listen, if your significant other doesn't come home, he's not answering the phone. She's at the home. She's at home with the oldest niece. The nephew isn't there. She's probably calling her mother for advice. She wanted to go home at that point. I don't think it's unusual for somebody to call their parent in a situation. She really doesn't have anyone else to call. Her significant other is not at the house at that time. And there's no one else. Who is she going to call when she's in a situation where she needs advice? The only other person you're going to call is your mother and father. And there was only one phone call. She didn't call her mother 10 times to wake her up to find out what she needs to do. It was one phone call, didn't answer, and then the next phone calls were at 4:55 in the morning. And then as far as the Boston 25, I mean, Ted Daniel himself clarified this. Boston 25 clarified this. There is no way that Bill Reed would go on air and openly admit that his daughter confessed to hitting John O'Keefe in an interview that's going to be seen by thousands of people. No parent would ever do that.
Yeah, and Kevin, if you watch the piece and the piece that aired after, I guess, the subpoena and after the first trial, it seems that the context of this hitting something is a conversation at the hospital. Are you hearing it any differently?
Yeah, I think that's what the case is. And what was always interesting to me is he's going on and doing an interview that they would have practiced for and gone over with the attorneys. Why is he releasing that? Well, that was the same time that they were leaking to court TV the audio, the ring video that showed Karen backing into John's Traverse in the driveway. So they're trying to run a narrative at that time. Now, I would think the prosecution would be interested in speaking to Karen's cousin Kelly, because my understanding from speaking to Natalie, who was working closely with Karen at the time, is that they didn't even realize that this video showed Karen backing into the Traverse until Kelly, who is a lawyer but not on the team, spotted it in the discovery material. So she was the one that figured it. So it's possible that Karen never knew that she backed into that vehicle. And this is something that Mr. Reed just put out as they were building this narrative in the summer of 2023, when they were trying to suggest that that's where the taillight was damaged. And just one more thing quickly, this going after the phone calls, this could be exculpatory too, because the idea is what if you find out that Karen has a history on other occasions of getting drunk and calling her mom or her dad? Because you have to ask, why didn't they answer the phones in the morning? Now, it could have been from the blizzard, everybody's sleeping, it was windy, everybody's sleeping through it, but maybe she actually has a history of doing this, getting drunk and getting upset on other occasions, which would be exculpatory to her. But if you don't have that pattern, then you have to ask, why was Karen calling at that time, and was it unusual?
Joseph, let me ask you about what the prosecution is looking for up in Massachusetts, which is the unaired portion of the Boston 25 interview, the part, right? When we do interviews in television, it might be 2 hours, and we put 20 seconds on if it's not a live thing. So there's some video that exists, I'm sure, of the interview that has not been aired. Do they get it or do they not get it in Massachusetts?
They absolutely get it, and that's probably one of the problems when you have a lawyer from Los Angeles. I don't know Valen Jackson. I presume he was aware. David Yannetti certainly was. There is not a reporter privilege in Massachusetts. The only exception is if you're trying to protect a confidential informant as the source of that information. When the source of the information here, Karen Reed and William Reed, are known, then all of the information is discoverable and it's not subject to any privilege. You got to ask yourself, why are lawyers having their client continually get out there in the public eye and speak and give interviews with different media outlets? There's really two explanations. One, they're trying to taint the jury pool, which is impermissible for lawyers, but Karen Reed's free to do it if she wants to do it. Or two, there's got to be some financial incentive. They're trying to gin up interest in the story, or perhaps there's contractual relationships with other media outlets, and we're going to see something after the trial. What you do, though, when you have your client speak, I think it was a learning lesson today, you do it at your own peril. They can't control the narrative. They can't have these cozy relationships with the media and go over the information they give and decide amongst themselves which gets published and broadcast and which doesn't. Attorney Brennan, these are admissions. These are incriminatory. These are material and relevant. We have an unfettered right under Rule 17 in Massachusetts to get them. And I'm telling you, he's going to get them.
All right. Well,
and look out.
I don't like that word cozy, though. Cozy makes it sound like we're on this, like, we'll interview whoever will talk, Joseph. That's the way the media works. If someone's associated with a big story, we're going to get the interview. It's not about being cozy.
Vinny, she had a reporter from Vanity Fair stay over her house for 3 days. That's pretty cozy. Come on. You know better than that.
No, I don't know better than that. I will interview anyone associated with any big case, period.
But you wouldn't go stay at her house.
If that's how you get the interview, that's how you get the interview. I don't know. All right. They're with us. They're staying with us, not going anywhere. When we come back, we're going to talk about Turtle Boys is in the news today, associated with some arguments made by the defense. You'll want to hear that, plus coming up next hour. Tonight on Vinny Politan Investigates the OnlyFans murder, Courtney Clenny, an internet star known for wearing very few pieces of clothing, is accused of stabbing her boyfriend and killing him. Was this self-defense? We investigate.
Join Court TV's Vinny Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinny Politan Investigates, tonight, 9/8 Central, only on Court TV.
What happened that night? Are you not prepared to take responsibility for any of your crimes?
Interview with a killer. Marathon starting Thursday, 11/10 Central, only on Court TV. Your future.
And I was attacking anyone who was in a fight with his owner. That's how we know that Brian Albert was involved. That's how we know that Chloe was involved, because not one, but two doctors, trained pathologists, who have looked at thousands of autopsy photos and testified in thousands of cases, all agree those are dog bites on John Clyde.
The man in the middle of all of those Karen Reed supporters, Aidan Kearney, also known as Turtle Boy, who's really the driving force behind the movement that turned into like something we've never ever seen. I mean, the numbers of people and the passion they have to support a complete stranger, Karen Reed, he's the one who really got everything started. So today he was in court. If you look at the man in the white jacket, on the screen right there, you can see him. There we go. He was in court today, which has not always been the case because he's not always permitted to be inside the court, depending upon who else is there. Let's take a listen back to the judge making a ruling excluding him at certain times of the Karen Reed case.
He wishes to be in the galley of journalists, like everyone else, and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Kearney. And there's absolutely no reason for the government to sneak behind my back to interfere with his First Amendment rights. It's outrageous, and on procedural grounds, I ask you to deny the motion.
My role in this case, Commonwealth versus Karen Reed, is to assure that the defendant's constitutional right to a fair trial are honored and upheld. And because of the chilling effect that Mr. Kearney's presence, I find, will have on the witness's testimony, I'm going to excuse him while the named witnesses in the Commonwealth's motion, Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, Jennifer McCabe, Matthew McCabe, Brian Albert, and Yuri Buchanan. And the Commonwealth also today requested Nicole Albert because of the incidents that reportedly have been held at her home. I'm going to excuse him during all of that testimony.
Okay, so what's the history? Well, he has his own case that is pending. Charges, 16 charges. Take a look. We'll put them up on the screen to remind you. 16 charges of witness intimidation. So he's got his own criminal legal battle that he is in the midst of. But that seemed to intersect today with the Karen Reed case. Take a listen to David Yannetti, Karen Reed's attorney, talking about wanting to get some phone records connected to the DA, connected to the case involving Aiden Kearney. Take a listen.
We were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phones. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not the emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days. That obviously raises some questions for us, maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication, and we'd ask that a more thorough search be done for these types of communications.
Okay, let's bring back in our guest, still with us, Nick Rocco, Joseph Krowski Jr., Kevin Lenahan. It's very convoluted and complicated. This is the DA, his phone records. Nick, from your perspective, what on earth is the defense concerned about when it comes to the DA's phone records that may or may not be connected to Turtle Boy's case?
Well, just the number one fact that he spelled Karen Reed's name wrong clearly shows that, one, he's either not paying attention to the person that he's trying to prosecute, or he's trying to hide the fact that he's talking about Miss Reed in the emails. And in some of those personal emails, he sent emails to the Chief Justice of Massachusetts District Court, the administrator for the trial courts, the deputy court administrator, also a sitting judge at the Stoughton District Court, and then his right-hand woman that's in the office. I believe her name is Lynn Beland. She is basically the second hand at Norfolk County. So you have all these personal emails getting sent to these people, and specifically one of them was to Judge, I believe it was Judge O'Malley in Stoughton District Court. In that situation, Christopher Albert went in for a harassment prevention order against Turtle Boy. The judge denied it. The next day, that judge received an email from Michael Morrissey's burner account to basically reprimand him and tell him that he has a leak in the clerk's office because one of the clerks apparently released public information to either somebody who gave it to Turtle Boy, but it came in his possession, and that's public information. And what he did, he went on a burner account, sent an email, and said, you need to make this right because now nobody trusts the court system. And it's right there in black and white. He wrote it himself. So there's stuff out there that this man has been talking about the Karen Reed case, and I'm sure that's why he's using a burner email address.
What's going on here, Kevin?
So in the early weeks that Karen and her defense team, because this is on the record, both Jackson and Eddie started feeding this information to Turtle Boy in order to whip up this frenzy. A few weeks after that, Turtle Boy goes to the daughter of Jen McCabe, one of the witnesses, her lacrosse game, in order to harass her in the stands. Now, we now have went over on my show information that came out from an admin meeting that Dick was part of, that Turtle Boy, when he was angry this past May 3rd, was saying that Karen was the one that had a message for Turtle Boy to deliver to Jen McCabe saying, did you think you could outsmart me? Now, whether that Karen really did that, we don't know, but Turtle Boy was making that claim, and they've had to try to contain this. Now, we fast forward to the end of the summer when this happened. The witnesses had finally, after being hounded mercilessly all summer, including by Nick Rocco, who I like, but yes, They went to the DA's office. First, they went to a Stoughton. They don't know what to do. They go to Stoughton District Court to get a protection order. And when that, perhaps they didn't know how to get that through right, then they finally go to DA Morrissey's office to beg him for help. And so Morrissey, understanding that there were leaks, and this has been documented, and more about this is going to come out after the trial. There are leaks to Turtle Boy because this is like a cult operation up here. He does have moles, including in the DA's office. This is a big problem. So he had to contain these communications. He certainly couldn't include the defense in it because they're the ones that were orchestrating this witness attainment and this witness intimidation, allegedly. But there's a lot of evidence for it, and I think a lot's going to come out on that.
Joseph Krasky Jr., I mean, people from the outside listening to all of this going on, it's like, what's going on in Massachusetts? Why would a DA have a second phone? Why is he sending personal emails to judges? Does any of this make sense to you?
Well, I think every district attorney would have a personal phone, right? They have a work phone that should be limited to work use and official use, and information on that is subject to a public records request. A FOIA request is what we call it in Massachusetts. And then you have your personal cell phone. Look, I think in hindsight, it was probably ill-advised to reach out to the judges, but I certainly don't think that he did it covertly and he thought that it would remain private because he sent it to several judges' emails. I think that the harassment that witnesses were subject to had just reached a cataclysmic point in that they were probably hounding him that they needed protection. And so I think he was frustrated that not only were they getting protection from the courts, someone in the court was unlawfully leaking information. I think in hindsight, he probably should have CC'd Jackson and Yannetti, and it would have resolved this problem. But Brennan knows what he's required to turn over. In Massachusetts, it's defined by Rule 14. Any statements of witnesses that are going to be called at trial, he has to turn over. And I think I heard him at the hearing say he's going through all of the information to make sure, and he has a very liberal approach to what he's required to turn over. And if there's anything in there that's exculpatory, he's required to turn it over. So it looks like since he's come on the case, he started fresh at A, and he's going to go A through Z with discovery.
Gotcha. All right, everyone's staying. When we come back, we're getting ready. Right now, it's scheduled for January of 2025, the Karen Read retrial. That was after the first trial. That was after the first trial. And we're getting ready for the second trial of Karen Read, right now scheduled for the end of January, although both sides want to push it to the spring. We'll see what happens. Let's bring back in our guests. We've got with us Nick Rocco, Joseph Krasky Jr., and Kevin Lenahan. All right, I want to take a look at some of the changes for Karen Read 2025. And it begins with this new prosecutor, Hank Brennan, appointed by the Norfolk County DA Michael Morrissey in September, 25 years of experience in state and federal courts, former defense attorney for Whitey Bulger, and did I say that right, Whitey Bulger? And Nancy Kerrigan's brother who murdered the father. All right, so Nick Rocco, is there any concern from the defense that, this guy's sharp?
No, I mean, he might speak a little bit better than Adam Lally, but I mean, the facts are the facts and the evidence is the evidence. Nothing's going to change regardless of who talks about it from the prosecution side. But as you can see, Karen is also adding people to her team. You're going to see a lot more defense experts this time around. It's not going to be, I don't think it's going to be a pony show like the last time. It was dragged out. I think we can all agree on that. It was dragged out by the prosecution. I'm hoping Hank doesn't drag it out that long. I don't think he's going to have to. I think he's going to have to call certain people, and the defense will call their people. And I think it's going to be a bloodbath in the courtroom. I really do. I think it's going to be a battle.
Joseph, what do you think? Is Brennan sharp?
He's the sharpest. I've known Hank for 26 years. We were both in the DA's office together in Essex County. We've handled many, many cases together. He's the best. There are lawyers that say they work 80 hours a week, and then there's Hank Brennan, who works probably 100 hours a week. The defense is going to need another table for all the lawyers they keep hiring, but you've already seen dramatic changes. In the first trial, the Commonwealth, and I don't know why, didn't offer into evidence some of the most compelling evidence in all of the statements and interviews Karen Read had given to the various media outlets. Attorney Brennan's already filed a motion to preclude the dog bite expert that the defendant was allowed to call that they had just retained 2 weeks into the trial. The defense has now hired outside experts that have not been self-trained in the state police. And right now there's testing going on related to the motherboard that was taken from the Lexus. So this is the different prosecution. And no disrespect to Adam Lally. It was a really difficult task. But yes, this is a different case now.
All right, something else going to change is Trooper Proctor's status, right? He's in a much different place now after the trial than before. Placed on administrative leave following the mistrial due to admitted unprofessional behavior. Currently under internal investigation, removed from 2 other high-profile cases up there. So Kevin Lenahan, is Proctor now even more damaged goods? And is that a big problem for the prosecution since he is the lead investigator?
No, I think he's going to testify. He's going to say the same thing, that he had very insensitive texts and he regrets doing them, but that doesn't affect the investigation. And there is no evidence of any investigation that he's been involved in his 5 years on the Detectives Bureau of any kind of fudging evidence or cover-ups or any kind of misdeeds. And there's none here in this case here. So I think, and just to comment on the change in prosecution, he does seem laser-focused and meticulous. And I think in the first trial, Adam Lally did a good job in debunking the conspiracy theory, however, did not do a good job of presenting the actual state's case in a way that was convincing how John's injuries occurred and so forth. And now I think the new prosecutor, Brennan, who is excellent, is going to be able to build on that. So they will continue to easily debunk this wild conspiracy theory, but now they're going to prove the state's charges.
All right, let's take a Nick, are there any other witnesses that, since the trial have had some issues?
I think we'll have to wait to see for the second trial there.
Sounds like you got something up your sleeve there, Nick. That's all I'm saying. That's all I'm saying. We'll see. We'll see. All right, let's get to one other thing that changed. The new defense attorney, Robert Alessi, awaiting Judge Canone's approval. New York lawyer, expertise, direct cross-examination. It seems like he can deal with a lot of scientific and technical backgrounds. Nick, you said they're adding to the team. This looks like it could be an important piece when you start getting into some of the more technical and scientific stuff.
Yeah, I mean, I don't know what role he's going to play yet. But he's also another bulldog that's added to the team. And I know Joe said, they're going to need a bigger table, but listen, if you need 100 to prove your innocence, up against a corrupt Commonwealth and DA, then you need 100. But it's like I said, I think it's going to be a very wild court case this time around.
Joseph, do you think this next trial is shorter, longer, same? And do you think it starts in January, or is this thing going to get pushed?
I think it's going to get pushed. It would be very rare with all that's at stake when both sides want the continuance, not to give them. I think it's a very modest request, 60 days, 90 days. I think it's a shorter trial. I think they probably don't chase the defense theory as much. Having said that, there's still a lot of witnesses. There's still a lot of technical information. So it's still not going to be a short trial, relatively speaking. But I'll still put my money on Brennan on this one.
Well, the other part is, and we talk a lot about the defense theory, is that the defense can have an altered theory as well in the retrial. Can't they, Joseph? I mean, if you have a defendant and you have a retrial, your strategy, your theory, your arguments to the jury can be different.
Sure, there's no judicial estoppel when you're talking about a defense. They don't have to put forward any defense. They can certainly infer it, argue it, but they're not required to prove anything. I think we've talked about the Commonwealth cleaning it up a little bit. I think that the defense would be wise to probably do a little bit less as it relates to the conspiracy theory, because it got to the point where it was just too unbelievable and implausible. And I think that the information that leaked out about the jury decision of 9-3 or 8-4, whatever it was, is kind of a rejection of the whole conspiracy theory. So I think they're going to clean things up too. They should.
All right. Well, I want to thank you guys for all your help during 2024. We may speak again this year, I'm not sure, but I want you to have a great Thanksgiving with your families and know that Court TV really appreciates your valuable time. Nick Rocco, Joseph Krowski Jr., Kevin Lenihan, thank you all so much. When we come back, I will reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, Courtney Clenny got famous on Instagram, then got rich on OnlyFans performing sex acts on video for her subscribers. Now she's famous on Court TV for putting a knife in her boyfriend's chest. Is she a killer or a victim? We investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
Time to reveal something else you need to know tonight. Let's take a look at the big board. What do we have? Life in prison. Who is that? Lori Shaver. Remember her? She's the one who shot and killed her husband, buried him under a concrete slab in the backyard, and then apparently is blaming the 7-year-old daughter for all of it. Wow. Well, today was sentencing day. Let's take a listen to some victim impact statements and then the judge.
Lori Shaver's manipulative and narcissistic behavior isolated Michael from his family and friends, depriving us of a chance to be part of his life. Her actions not only led to his tragic death, but also perpetuated a harmful narrative that tarnished his memory and caused further pain to his loved ones, especially his children. Her actions did not stop the day she took his life and buried him within sight in her backyard.
I've never seen a man more dedicated to his children than Mike. If spirits exist after this life, I'm sure his is gutted at the lies and brainwashing used on his daughter. Those of us who know them all 100% know that things stated she claimed to have done so were impossible simply based on her tiny size at the time. He was a smart, funny, caring, and wonderful man. The world is truly a worse place without him in it.
Lori Shaver Filmer, in case number 2020 CF 2361, having been found guilty by a jury of your peers of the offense of murder in the second degree with a firearm and having been adjudicated guilty of the offense of murder in the second degree with a firearm, the court hereby sentences you to a term of life in the Florida Department of Corrections. Standard fines, fees, and costs will be assessed. Mandatory court costs will be assessed. You will have 30 days to appeal.
Convicted and sentenced to life. I need your help. Take a look at the screen. We have a missing child. This is Alexis Rain Crabtree, just 15 years old, missing out of Aurora, Missouri since November 20th of this year. She may stay in the local area or travel to Springfield, Missouri. Alexis may also go by the name Lexi. So if you see Alexis, make the call, make a difference, 911, 1-800-THE-LOST, or you can call the Aurora, Missouri Police Department. That phone number's on the screen. Let's get Lexi to a safe place tonight. Don't go anywhere. We've got another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.